You're listening to The Edge 105 FM. 105 FM. 105 FM.
It is season 6, episode 7 of Legal Landscape. All these new high-rise apartment buildings, now what? Across Jamaica and especially in Kingston, we can see a new high-rise apartment building built all over. These types of buildings are governed by strata rules. What are some of the issues that can arise from having so many people living in one building, and how can people address issues that come up? We are joined by Kelly Akin, a partner in the corporate and commercial department at DunnCox Attorneys-at-Law, who will guide us in understanding more about stratas. Kelly, thank you for joining us.
Hi, thank you for having me.
Well, it's always a pleasure. Legal Landscape always hits the button for us and gets the point that we didn't think about with so many topics, eh? So let's go easy first of all. What do you mean by strata, Kelly?
Alrighty, so Jamaica has a law called the Registration Strata Titles Act, which for the most part addresses, the maintenance and operation of a high-rise residential or even commercial building. I would point out that the law, however, does not cover townhouses and other gated communities, like, for example, Caribbean estates that would have those individual homes. Mm-hmm. But the law does look at, like I said, apartment complexes, and I guess to an extent some townhouses, but we're not going to focus on that. Really, mainly those apartment complexes. Each of these buildings in these developments would be put on a strata plan, and that plan is registered by the developers at the titles office, before they hand over to the new owners. And each unit, and when I say unit, I mean apartment, would be called a strata lot. So each individual apartment would be a strata lot. And the operation and maintenance of that development would be handled by what we call a strata corporation.
Okay, so you'd say the strata corporation, what is that and what do they do?
It's a good question. The strata corporation for each development is typically, or it is made up of all the owners of those units or strata lots, as I mentioned. The corporation is registered and pays fees to the strata commission. There's two entities here, the corporation and the commission. The corporation, of course, being made up by the owners, and the commission is the regulatory body that oversees the implementation of that law that I mentioned. Now, the corporation also determines things like what amenities the complex should have. When you buy into these nice, fancy new high-rises, you see that they have a pool, security guard, gardener, gym, common area Wi-Fi, and all of these nice things. The corporation would also appoint an executive body who would make decisions on how to put in place those agreed amenities. And of course, when you're putting in place those amenities, the corporation must also now figure out what is this monthly maintenance budget. How much money do we need to run all of these things?
Mm-hmm. So if we need money to run all of these things, then Kelly, how is the maintenance split?
Well, so maintenance is actually, first of all owners must contribute to it. And contrary to what some people may think, it is not split equally. So if you have 20 units, it is not divide the budget by 20 and everybody pays equally. It's actually split based on what we call unit entitlement. And that typically goes based on the physical size of the unit. So a good rule of thumb, I think, is if someone's unit is about double the size of another person's, for example, a 1-bedroom versus a 2-bedroom, on average, the person with the 2-bedroom would have double the monthly payment of the person with the smaller unit. And you have to be careful, though, when you're splitting maintenance, because the commission actually inspects the breakdown of maintenance with those annual filings, and they have that regulatory oversight.
Okay, you're listening to Kelly Akin, a partner in the corporate and commercial department at DunnCox Attorneys-at-Law, and she's guiding us through this to understand more about stratas. You mentioned maintenance split. Then what happens, Kelly, when people do not pay their maintenance?
Now, I know this is a common thing that people have been having issues with. So under Section 5 of the Act, the Strata Titles Act, if someone does not pay their maintenance, and when I say don't pay it, I mean, like maybe about 30 days plus overdue, the corporation has a couple options open to them. First one would be, of course, charging interest on those late payments as it accrues, similar to how the banks like to do it. The other thing that they have open to them is exercising powers of sale over the person's units. I mean, I have to highlight that if someone does not pay their maintenance, the strata corporation has the power under law to sell their apartment. I mean, of course, I will say, though, that there is a procedure to follow if they're going to exercise that type of power under those circumstances. But I think it's something that is so far-reaching that needs to be highlighted to persons, when they're entering into these type of developments. The other thing I would point out in terms of persons who don't pay their maintenance, I've seen situations where strata corporations will instruct, for example, the security guard not to open the gate for someone who is delinquent. I should point out that you are not allowed to bar someone entry from their property, but the effect here is that if you're not paying for the benefit of having a security guard open the gate for you, you should come out of your car, open the gate yourself, close it back. So those are some of the things that I've seen implemented by corporations.
Do you have any common examples of restrictions? That sounds like you're really going to the extreme for some persons. Can you give us some common examples of restrictions as well, the rules that are usually in the strata rules, the bylaws?
So typical ones that I've seen are, for example, very common, no pets allowed. No. And this is important because on their annual visits to the property, I've seen instances where the Strata Commission has heard a dog or seen a cat run across the way, and they say, well, the bylaws state there should be no pets. And if they see these animals, they will actually request to see in writing any sort of amendment or consent through the bylaws to have these pets. Another common one is restrictions on short-term rentals, and that covers things like Airbnb. And I caution persons who buy into these various apartment buildings with the intention of hey, I'm going to rent it out, make a little extra money on Airbnb. People be in and out, and it's flexible. But if the bylaws don't allow for it, then persons who do that may be running into issues with the corporation themselves. Another one, of course, would be loud music or noise beyond a certain hour. But, I say all of these things, but it's important to understand that the corporation can agree by a 2/3 majority vote of all the owners who have paid up their maintenance, of course, that they can amend these bylaws to allow for those pets, or maybe you only want dogs and you don't want cats. You allow Airbnb, but that sort of consensus must be had.
So a benefit then is that if you're in a strata, you may have a say in how the strata is run.
Exactly.
But if the breaches of the rules, how are the breaches really handled?
Well, under the law, if there's a dispute over a strata-related issue, a complaint can be made to the executive of the corporation. Like I said, the corporation would have appointed an executive body, a subset who kind of manages the day-to-day operations of the development. The executive would come to a decision on that issue, and if the owner or the person who the decision would have not been in favor of is not happy with it, they can make a complaint to the commission. And now the commission, a decision made by the commission, has a similar effect to a decision made by a court of law.
It's a lot, always interesting. I so look forward to hearing the points that you advise us on in the legal landscape. And
we're always happy to do it.
And I also look forward, do you have any tidbits that you can share with us? Like what's your hashtag, did you know tidbit?
Well, it's more of a did you know? So as we're talking about strata lots, the strata lot number that is on someone's title may not coincide with their apartment number. So you may have lot 2, but you may be apartment 4. And there are situations where persons were handed the wrong apartment simply because of that little difference. So it's important to know those little nuances.
This is why we need people like you, Kelly. So if you're going, make sure your lot number is your strata number, is your title, all sort of things to just navigate through. Thank you so very much. Kelly Akin is partner in the corporate and commercial department at DunnCox Attorneys-at-Law. And I certainly hope you enjoyed as much as we did here. The new high-rise apartment buildings, stratas, now what? Thank you, Kelly.
Thank you for having me.
If anyone has any questions about this topic or any other legal queries, where could we go to?
You can always come to our website, DunnCox.com. That is DunnCox.com. You can look for my name. You can chill, and we will respond to you any queries that you have.
As easy as that. Thank you so very much once again, Kelly Akin, and so I hope you enjoyed listening to Season 6, Episode 7 today, Legal Landscape. Thank you, Kelly.
All right, thank you.
Well, were there things there that you didn't know, that you weren't aware of? Is a strata more attractive to you now or not so attractive? That's why you have to listen to this program. Join us next week. We will have another in the series, Legal Landscape.
You're listening to The Edge 105 FM. 105 FM.